So the document that you are looking at has been posted as a Word document and also a PDF document on Edsby. Will I be kind of typing notes and answering these questions as we work through this? Yes. Yes, I will. Do I still think that it is in your best interests to take the notes yourself? Yes, I absolutely do. Um, so take that as you will. Chapter 12 is the second half to our unit on civil law. We know that civil law is all about private disputes. It is all about victim compensation. We do know that there is such a thing as a civil suit also being connected to criminal acts, especially if things are related to things like assault, right? If someone were to assault you, that would be criminal. But at the same time, if in their assault of you, they you experienced physical harm, and you had to go to like physio or like a chiropractor or something like that, or if you had to miss work because of your injuries, so there's money out of pocket. Those are things that the courts are there to help victims with. And we know that there are actually all sorts of different types of damages that can be sued for: general damages, special damages, punitive damages, injunctions. Actually, why don't we spend a little bit of time reviewing those? I realize that it feels like a long time ago that we talked about them, but if you want to get out your notes from chapter 11, why don't we talk about the different types of damages that people sue for? Remember, damages are things you want, you're seeking them. Okay, it doesn't mean you're injured. Damages is a term in civil law that we use for victim compensation. You sue for damages. So that's a specific vocabulary term. We don't have to go in any particular order. Here's the list: general damages, special damages, punitive damages, injunctions. I think those are kind of the main ones. Does anybody want to pick any one of those and kind of give me a bit of a recap on?
I think special damages, they are the ones that compensate for like monetary loss.
Well, you're on the right track in the sense that I always call special damages specific damages, like keep your receipts. They're actually fairly easy to tabulate. So for example, for special damages, let's say someone grabbed your phone and just decided to smash it with a hammer. Oh, it's just a prank, bro. Well, now you have an issue of there's actually some criminal activity that's taken place there, right? You have mischief, you have damaged your property. But on the civil side of things, you could sue for the replacement cost. And so special damages are really just have to focus on, well, how much would it actually cost to replace that exact item or something similar? You have to remember this though, that the true nature of special damages, it doesn't mean like, and I think I mentioned this in another class, I still have an iPhone 6S. It still works and it does everything I need it to because I basically need it for WhatsApp and Clash Royale. But if someone were to destroy my phone, that doesn't mean that then I get to say, well, now I'm going to sue you for whatever the newest iPhone is. If I were to seek special damages, really, I would be looking at the replacement cost of that particular device. And, with electronics, the nature tends to be that over time, the amount, tends to go down. There was actually a time, believe it or not, in the late 70s, early 80s, when the cost of a VCR, which are now completely obsolete, the cost of a home VCR was actually the same as a brand new Ford Mustang. You can look it up. You don't have to take my word for it. But when the technology was so new, the idea of you being able to have a movie in your own home on video cassette, the technology was so new that the cost of it was, beyond what most people could afford. And then obviously over time, technology advances and things can sometimes become obsolete. But special damages are out of pocket expenses. So that's one of them. That's actually the easiest one to tabulate, right? Keep your receipts. What's another type of damages that may be sued for?
I think there's one called
Nominal.
punitive damages. And it's if like the defendant is acting really badly in court and is being a jerk, then the judge can give like additional money to the plaintiff. And it's like it's a message to society so that it's a reminder that you shouldn't be like treat others horribly in court.
Yeah, and I'm glad that you mentioned that really it's at the judge's discretion whether or not to. And again, I'm not a lawyer or a judge, but in all of the research that I have done, I'm under the assumption and the understanding that punitive damages are not things that you, as the actual plaintiff, seek. They are discretionary on the part of the judge. If the judge feels as though the defendant was acting, as you said, just like really a jerk, like they tried everything they could to, drag this on, and they were unreasonable. They just made the plaintiff's life a living hell, as they went through this. The judge has some discretion to kind of award the plaintiff additional money in the form of punitive damages. And again, it is designed to be a bit of a deterrent, to kind of say to society, listen, it's better for you just to, make things right than it is to, treat people like garbage and drag them through things. So that's covered special and punitive damages.
Nominal damages. So these look at, it's not necessarily about the money, it's about the principle. So it's being told you are correct or you're right.
Yeah, that's kind of an interesting one because, I think in my notes I said it's not about the money. Because nominal damages, you'll find that sometimes nominal damages are, sometimes used by people who are already kind of like wealthy and successful, because they're saying, listen, I'm not suing because I need the money. I'm suing because this is a matter of pride or a matter of principle or a matter of reputation. And I want to, bring this forward. I'm not going to let this stand. So yeah, nominal damages are when you're not really seeking money. You are basically wanting the courts to tell everybody that you are correct. So this is typically one that, yeah, you have to really, it really has to be something that you are passionate about, or something about like your reputation. It's probably not going to be the sort of thing that somebody's going to do over, like, let's say I'm the cheapest man alive, but if somebody, ripped me off at a garage sale, for the sake of a $20 item, that might be a life lesson, but I'm not going to bother trying to take that to court because, quite frankly, it's not worth it. So we've covered nominal, punitive, special damages. What about general damages? General damages it's actually kind of hard to pinpoint exact dollar amounts.
I think it's like, I don't know. I just think that it's like if something bad happens to you and they caused it, it's just like they have to pay money. That's basically how I understand it.
Well, the way that you calculate, there are a number of things that can fall under the category of general damages. But again, if you double check in your textbook, you'll see that it's not easy to put a dollar amount on certain things. Now, I realize that we were looking at it through small claims court. So you're probably not dealing with things like loss of an arm or loss of a leg, because then you're dealing with, major lawsuits. But you could look at something like a pet, for example. If someone were to injure or kill, your pet, as a result of, carelessness, right? You're just walking your dog on the sidewalk and somebody's not paying attention and they, hit the curb and come onto the sidewalk and they wind up, hitting and killing your dog. Special damages would kind of cover the actual cost of like replacement of the animal itself, right? If you're like, well, how much does it cost for another dog? But special damages doesn't cover the pain and suffering and the like. It's not just about replacing the dog. It's not just, you can't just go out and buy me a new dog and then replace the dog that I had. Like that dog was, like a part of our family. And to treat it as just a matter of, oh, well, how much does it cost for a new dog? It is kind of a callous way of looking at it. So general damages cover things like pain and suffering, which again can be tricky because how do you put a dollar amount on that? That might be something that you need to consult a lawyer to sort of, get some idea of precedent and cases that have existed in the past. But when you talk about putting a dollar amount on something, I don't know about you, but I've actually been cleaning out my house a lot over this Christmas break, and we've been throwing out and purging a lot of things. There are some things that have deep emotional connection to, even though they're technically worthless. I actually have an old toy dart gun that is probably 25 years old. It doesn't work, and it was from the dollar store, but I keep it. And the reason I keep it is because I actually have strong memories of, playing these dumb made up games with my brother. And we used that, broken dollar store dart gun. So that's the kind of thing where when you talk about stuff like nostalgia or, deeper meaning of something, it's not always about what the actual cost of replacement is. It's tied to things like, pain and suffering, things that are hard to replace. That's one of them. Another aspect of general damages, and this is sometimes a trickier one to calculate, it's called loss of future income. Is that ringing a bell for anybody? If I say loss of future income, does anybody remember what that means? It's not like they took actual money out of your wallet.
Like a job, maybe.
How so? Can you expand on that a bit?
Because let's say, for example, like I were to slander you, and then like you'd get fired. Then you could say, well, it wasn't true, so therefore, and I lost my job, so therefore, I lost future income.
That's actually a really good example that we weren't even going to look at yet, because slander and libel and defamation suits are in chapter 12. So that's a good fast forward. But yeah, that is a good example. So yeah, that's a great one. I'm going to simplify it to also say, if we look at something like a medical condition, like let's say, again, let's go back to a car accident or something like that. Let's say that someone was drinking and driving and, they hit you and they're at fault and they're facing criminal charges for all that sort of thing. But the result of the car accident, you broke your leg. You didn't lose your leg, but you broke your leg. And while you were, in the hospital and getting the cast on, there were a couple of weeks where you couldn't go to your regular job. And, at your regular job, you maybe before you were working part-time and you're making, 20, 25 hours a week at a certain dollar amount. Well, that's money that you would have made, but you didn't, because you were recovering. You were recovering because of somebody else's mistakes. Somebody has injured you, and that has prevented you from being able to go out and do your job. So yeah, loss of future income, and Matthias' example is a good one as well, is, you kind of doing the math to say, all right, this is how much work I missed out on. This is the dollar amount that I made. And, this is the money I would have had if I was able to continue doing my job, but I wasn't because of the defendant's actions. And so loss of future income is also something that can be calculated in general damages. Now, where this gets a little bit tricky is, if we look in the world of it has to be based in reality and something that a judge would believe. Like, you can't say like, oh, well, Your Honor, like I was gonna go to the local convenience store and I was gonna buy a lottery ticket, and the numbers I was gonna pick were gonna be the winning numbers. And I didn't get a chance to do that because I was injured. And so really, I think now the defendant should actually be on the hook for my future lottery winnings, which I would have won if it weren't like that. That is not going to hold up in court. Does anybody have any questions on? It's a good recap from last semester, not last semester, before the break. Any other questions on damages and suing for damages, the types that you would seek?
One question for you. When we go back to general damages, looking at like loss of future income, could what's the word? Your sorry, I'm drawing a blank now. Reputation. Your reputation. Like if you get accused of something that turns out you didn't
I'll
do.
put that on. I'll
it?
put that on hold for now, simply because that does kind of connect back to what Matthias had said before, the issue of slander or libel, which are forms of defamation. And like, if someone has said something that has had a negative material effect on you, for example, loss of job or that sort of thing, then there is there is the potential for you to sue in a defamation lawsuit to try to recoup those damages. The sad reality, though, is even though there are some means of being able to go after people that make unsubstantiated claims, the biggest danger and the biggest harm about rumors are the fact that you don't always know where they came from. Sometimes they're hard to pinpoint. That's why we say, your reputation is one of the most precious things that you have, and you want to protect it at all costs. This actually goes back to in criminal law when we talked about the idea of character evidence, right? This is why it's so incredibly important for you to treat everyone with respect, to treat everyone with dignity. It doesn't mean you have to be friends with everybody. I mean, let's get real. There are people that probably drive you nuts. And there are people that, there's even a Bible verse that says, if it is possible, as far as it depends on you, live at peace with everyone. Even that, makes, there are going to be people that just don't want to live in peace with you, despite your best efforts. You don't have to be friends with everybody, but you do want to make sure that you live your life in such a way where you are a person of honor, you are a person of integrity, you treat people with respect. And the reason why that really does begin to pay off is because then if there was ever anybody who was trying to make a false accusation about you, you would want everyone in your circle to rush to your defense and say, that doesn't sound like this person at all. I don't buy it for a second. Whereas if you are kind of a shady person, if you do have kind of a reputation of like, well, yeah, I don't know, they do try to kind of take advantage of people and they do kind of say they're going to do one thing and then they don't. If you don't have a strong reputation, then it's going to make it a lot harder for you to potentially defend against even an unjust accusation. Right? It doesn't make it right, but it's just, I'm saying in the real world, your reputation is one of the most important things for you to protect. It's almost 1 o'clock, and that's fine. We will still have a break, but I do want to answer a couple of questions here in chapter 12. So, why is negligence the most common form of tort law? And I'm going to answer this by actually answering another question, which I think is a little bit later. Nope, that's fine. I'll answer it up here. So the 3 elements of a negligent act are as follows, and all 3 things must occur in order for there to even be a potential lawsuit. Okay, it must be unplanned. Must be unintentional. And it must result in injury. So this is kind of the first part to answering this question. We have to sort of talk about, and I'll actually share my screen, do a new share over here. And you'll actually see where my mouse is hovering. You can see my mouse cursor, right? Hello? People?
Yes, I can.
Okay, good. So notice over here, the tort of negligence is one of the most important areas of tort law. Negligence has three characteristics: unintentional, unplanned, and results in injury. All three of these things must be present in order for you to even have something to move forward with. Okay, let's unpack all of these things a little bit before we move towards our break, because I think sometimes this is where people get confused, because you're like, oh wait, so let me get this straight. You know, if I don't mean to do something, or if I do mean to do something, I can't get in trouble for negligence. So let's look at all these things. Why must negligence, a negligent act, meaning something in this, remember we talked about criminal negligence, right? The idea of like, I didn't do something. Yeah, I know, that's the problem. Why, this is a follow-up question, why must negligence be unplanned? Logically, why must the very nature of a negligent act be unplanned?
Because if you plan to do something, wouldn't that be criminal?
Well, it's not necessarily criminal, but it is deliberate, right? Like you meant to do it, right? And if you mean to do something wrong to someone, that's still bad, but that's not negligence. And I want to clarify here, it doesn't mean, so if you're like, oh, so if I hit somebody in the face with a snowball, but I meant to do it, then I'm okay because it's not negligence. No, you're not okay. You intentionally threw a snowball at somebody. And if they weren't, you know, having a snowball fight with you, and it wasn't just kind of a fun prank, if it's just some random neighbor on the street and you hit him with an ice ball in the face, that's not okay. So if you plan to do something, it isn't negligence. It is deliberate. And that is a whole other sort of wrong. That's the kind of wrong that we talked about in chapter 11. Okay, remember, negligence is unique because it's not about what you meant to do. You actually didn't mean to do it. And this is kind of one of the answers to why negligence is the most common form of tort law, because it is the sort of thing that the defendant didn't mean to do, but they are still responsible. Why must, if I could type, a be unintentional? And to answer this question, the best way is for you to think back to your lexicon of legal terms and think what intent is. Why don't we start with that? What is intent?
What you wanted to be the outcome of your actions?
And I know it kind of feels like we're going in circles, but the whole point of a negligent act is that I didn't mean to do it. Okay, I didn't plan this. I didn't mean for it to happen. Okay, sure, you're still responsible. A negligent act must be unintentional, because if you intend to do something, well, then it's not negligence, right? It's a whole other sort of wrong. And this also connects back to the idea of planning. If you intend to do something, you usually, like, planning and intent tend to go together. So if you're planning to do something and you have an intended consequence in mind, that might be a wrongdoing, but it's not negligence. Why must negligence result in injury? Because if no one gets hurt, think about it logically. Why must negligence end in injury if we're going to have some sort of lawsuit?
There can't be a lawsuit if no one's hurt.
Why?
Because
What's the point?
What, that's what I'm asking. What is the point of a lawsuit? What's the point of civil law?
To compensate for injury.
Yeah,
The
to
other
compensate
things.
victims. And if nobody gets hurt,
Then there's no victim.
there you go. Right? If no one gets hurt, there is no victim, and thus no need to seek compensation. There are some near misses. Okay, does anybody know what a near miss is? You don't have to give me an actual example, but just try to describe what you think a near miss would be.
Something that's very similar, but like misses the mark of being a complete definition of it.
Yeah, I suppose so. I wasn't really thinking about it from a scholastic point of view. I was kind of looking at it more so from, like, really things that almost went terribly wrong, right? The idea of a near miss would be like, oh, I was texting and driving, and then at the last second, somebody said, oh, look out, there's somebody crossing the street, and you slammed on the brakes and you almost hit them, right? That would be an example of a near miss. Let me ask you this. If someone almost hits me with their car, do I have grounds for a civil suit?
No.
Not really, right? Like, I may have grounds to rant and rave and be angry and say, like, hey, watch where you're driving and all that sort of thing. But realistically, you know, if someone almost hits me with their car, there's really no way that I can convince a judge that I deserve compensation, because they're going to say, well, what are the extent of your injuries? And if the extent of the injuries are simply just, well, I was scared that I almost got hit by a car, you know, the judge would probably say that there's not enough there in balance of probabilities for me to actually grant you a monetary win. Because if you're not actually injured, then there's no real lawsuit possible. I mean, you should just be thankful that nobody was hurt. There's lots of near misses. But yeah, negligent act must result in injury, because again, if nobody gets hurt, then there's no victim, and then therefore there's no need to seek compensation. Let us do the following. The current time is 1:08. Let us take 15 minutes or so. I believe that would bring us back to, 1:23. Well, wait, hold on. Isn't my math is no? Yeah, that was close. 1:22. Nope, 1:23. If I keep talking, it'll be 1:24. Let's just do that. Okay, we'll reconvene at 1:24. I will pause recording at this time. Now, I know this doesn't make for the greatest watchability. But then again, I'm not recording these for the sake of getting thousands of YouTube views. I'm doing it specifically for this class. And as I mentioned, while I wasn't recording, originally I was going to get you to do some of this reading on your own. and then come back and answer some of the questions. The reality is Edsby appears to be down, so we will have to adapt. And as such, what I am going to do, because I am screen sharing, I'm going to read to you. So I'm going to be reading directly from the textbook for a little while. And after we've taken some time to read through the textbook, we're then going to bounce back to the question sheet, and we are going to try to work our way through the answers. Let me just finish drinking this coffee that I brewed during the break. Delicious. Okay. The tort of negligence is one of the most important areas of tort law. Negligence has three characteristics, which we've already discussed. The action is unintentional, it's unplanned, and an injury results. Anyone who carelessly injures a person or a person's property should compensate the victim for that injury. But carelessness alone does not make someone liable, meaning legally responsible, for negligence. Someone must actually be injured by the careless conduct. For example, if Liam does not clear his slippery sidewalk after a winter storm, he will not be liable for negligence unless somebody actually falls and is injured. If Alden does slip and fall, Liam might be liable in any legal action that occurs. Now, I want to be clear with this. This doesn't mean that, if you're looking to make a quick buck, that, oh, okay, well, now there's been a snowstorm, so I'm gonna, run up to all of my neighbors' houses and just see, which one I slip and fall on, because if I slip and fall on one, then I'm gonna, call the cops and be like, hey, you didn't, shovel your walk. Now I've been injured and I'm here to seek compensation. It's not as easy or as open book like open and shut case like that. There's a lot of other factors to consider. Other examples of negligence include car accidents, injuries to consumers caused by defective products, medical and legal malpractice. There are also intentional torts. Okay, we know about this from chapter 11. When a person deliberately, meaning like, again, on purpose, causes harm or loss to another person by assault and battery or false imprisonment, it's an intentional tort. Trespassing, causing a nuisance, defaming a person's reputation are other intentional torts. Intentional torts are the oldest wrongs recognized by the courts. If one person hits another, is it an intentional tort? The answer depends on a number of factors. The most important element of an intentional tort is intent. Intent is, no surprise here, it's the same definition that it was earlier, the true purpose of an act, a person's hope or desire for the result of an action. If Matt punches Josh squarely in the jaw, harm is clearly intended. But foreseeability, which we will also talk about a little bit later, is also a factor. If your friend Renu, or Renu, I don't know how to pronounce it, it's a fictional character, throws a snowball at you and it hits you in the face, causing damage to your eye, that is an intentional tort. Renu should have realized that the snowball could hit you and that injury could result. She would be responsible for the damage to your eye. Renu was in control of her actions. Thus, the tort would be considered intentional. The result would be the same if Renu hit a passerby, even if she did not intend to hit that person. So you can't use the excuse of, oh, I wasn't aiming for you, I was aiming for somebody else. Well, it doesn't matter. You were in control of your actions. I actually pranked my sister before the lockdown. She didn't see me coming and was getting into her car. And as she sat down into her car, I took a big handful of snow and shoved it in her face. And that was definitely intentional. But then I ran away. And I mean, she knew who did it. But, what does that have to do with it? Nothing, I guess. Anyway, moving on. However, many acts do not result in torts. That would actually be a good example of that, right? I knew who it was. It was my sister. It was a silly prank. Nobody got hurt. That's not something that I would do to some random passerby, right? I mean, the way in which you talk to people and your friends is going to be a lot different than the way that you might interact or talk with complete and total strangers. A certain amount of interference with individuals' rights occurs on a daily basis and is considered acceptable in busy society. Brushing against bodies on a crowded bus or subway, touching someone lightly to get their attention, or taking a shortcut across someone's property are actions that are accepted generally as a normal part of life. Unless they are done in a hostile manner and cause serious harm or fear of harm, they are not considered torts or wrongs. Beware the consequence of throwing an icy snowball. And again, you may, and this will hopefully you'll have some sympathy for the school later on as we talk about the concept of social host liability, because sometimes you will hear Mr. DeBoer come on the announcements and say, hey, everybody, if you're playing on the field, don't throw snowballs at one another. Again, you might be like, oh, you know, this is so typical of, you know, they don't want us to have any fun. Well, no, it's not that we don't want you to have any fun. It's actually partly the school's way of covering itself from liability. Because if people get injured and they're having a snowball fight, you might say, well, isn't that just their problem? Well, no, if it's happening at school, there's actually a certain amount of responsibility on the part of the school, which is actually known as an occupier, to ensure that everybody is well taken care of. We can't control everybody's actions, but that's one of the reasons why sometimes it seems like organizations are sort of saying like, oh, we don't want you to have any fun. No, it's not that we don't want you to have fun. It's that we want to make sure that we are, you know, covering ourselves, you know, from potential lawsuits. We have to care. We can't just say, oh, go out there and do what you want, because that would actually be irresponsible. So again, the elements of negligence are shown in figure 12-3, are described in more detail on the following pages. So I'm going to be showing you a video, terrible acting, but the acting is so bad, it'll probably stick with you. And the aspects of a negligence case are the following: duty, breach, causation, and damages. In fact, I'm going to go back screen sharing over here. Duty of care, that's later on. If I scroll down, here we are. Outline the 4 elements of a negligence case. I'm going to do that right now. Duty, breach. Well, I guess I can get rid of the period. Causation and damages. I'm actually going to do damages right now because we know what that is. Monetary compensation. It is what the plaintiff, notice that language hasn't changed, the plaintiff is the one seeing, is suing, is seeking as compensation for injury. So really the rest of what we're going to be looking at, you know, today is trying to make sense of these terms: duty, breach, and causation in regards to negligence. So we can actually start with this one. Okay, define duty of care. And you can actually see that over here. Okay, so the plaintiff is owed a duty of care. For example, in a car, a duty to, you know, basically follow the rules of the road. If you're a store owner, you owe a legal obligation to ensure that your store is free of, you know, hazards. And, you know, that could be something as simple as making sure that, you know, like a wet floor sign is down if you've mopped, you know, that sort of stuff. The level of care that is owed to a person varies depending on the situation. One of the things that you have going for you is the fact that you are all currently minors. And I know that can sometimes be frustrating because you're like, oh man, parents just tell me what to do. Adults are always telling me what to do. I know it kind of feels like that. But at the same time, you also have an incredible amount of protection under the law that adults don't have. Adults have full responsibility under the law. And so failure to do something that you're supposed to do, the consequences can actually be much more serious for adults. And again, I'm hoping that in looking at this chapter and continuing to have this conversation, it may actually give you some sympathy for some of the rules that, you know, your parents have placed upon you. in regards to, especially, if you're starting to drive, and they may have all sorts of rules like, oh, you can't listen to the radio, you can't do, and you might go, oh, this is so stupid. Why are you? You will have a better appreciation for why a lot of those rules exist as we continue to work our way through this chapter. So, duty of care. In a negligent suit, the plaintiff must show that the defendant owed the plaintiff a duty of care. Okay, so I'm going to bounce back over here. What is duty of care? A legal obligation that one owes to another. In a negligence case, the plaintiff, the person suing, must demonstrate that the defendant, person being sued, owed them a duty of care. Not everybody owes every single other person in society the same duty of care. In fact, again, as minors, generally speaking, as you go about your everyday life, you don't really owe people, a duty of care, other than the fact that you need to obey the laws of society and make sure that you're not, violating those sorts of things. There's still, property rights and all those sorts of things. But for example, especially for those who have, either your G1, or I don't know how old you guys are, potentially a G2, anytime you are behind the wheel of a car, you owe every single other driver on the road a duty of care. And that duty of care is to ensure that while you are behind the wheels of the car, that you are operating it in a way that is lawful and safe and responsible, in the same way that you owe pedestrians a duty of care, right? You're in a 4,000-pound death machine. So if you see someone crossing the road and you think to yourself, well, they shouldn't be crossing the road. I mean, I'm a car, I'm supposed to be on the road. And no, you actually owe them a duty of care, even if they are jaywalking, right? The pedestrian, if you try to say, like, well, they shouldn't have been crossing the road, so I mean, I hit them, but it's their fault. That's not going to work in court. They're going to say, you are the operator of a automobile. You have a higher duty of care than a cyclist or somebody who is a pedestrian would have. That's something that you actually need to know. Okay, and you don't always have to sign a document in order to have a duty of care, right? You can assume that responsibility depending on the position that you happen to be in. So again, like I said, if you are driving a car, that's a classic example. You owe every other driver and every pedestrian a standard of care, to obey the rules of the road, to be responsible, to be thoughtful, and to make sure that you aren't, doing stupid things. Your actions must not cause harm to people or to their property. This principle is central to the study of the laws governing negligence. In an earlier example, the municipality placed upon Liam a duty of care owed to pedestrians, that he must keep his sidewalk clear of ice and safe for anyone walking by his home. Next comes breach. Breach, well, let's go to Call of Duty as an example. Anybody tell me, within the realm of, Call of Duty, or it doesn't actually have to be Call of Duty, what the term breach refers to?
So breach is, when you put an explosive on a wall, and then, you throw in your concussion, and then you go into like the house or whatever you're raiding.
So what are you doing to the wall or to the door?
Destroying it, blowing it.
To break. That's exactly what you're doing. Okay, so that can be a helpful reminder. You breach a door, you're going in, right? You're breaking the door. So we know duty is a legal obligation one owes to another. A breach is to break. What is it that you think that you are breaking?
The duty.
Yeah,
Legal.
exactly. The aforementioned duty that we just described, right? To break. The duty that was owed. If I got in my car right now, I would owe every single other driver on the road a duty of care. That's fine. Generally speaking, I get through the day without having some sort of accident. I haven't had an accident in a very long time. The fact that a duty exists doesn't mean that you have a lawsuit in place. In order for there to be a lawsuit, there also has to be the next step, which would be a breach of the duty that was owed. Okay, so these are all connected together. Duty, breach, causation, and damages are all connected together. Okay, a breach would be to break the duty. And again, a classic example, if we use vehicles, like I was saying before, if I decide that I want to text while I'm driving, or I decide that I want to speed, or I decide that I want to do, unsafe weaving in and out of traffic, or I decide I want to run a red light, any and all of those actions could be considered a breach of duty. Now, here's the next question. Just because someone breaks a duty, is that enough to get us a lawsuit? Think back to the three things that have to be in place in order for a negligent act to move forward.
No,
No.
it has to result in injury.
Yeah, there has to be some sort of injury. So think about it this way. If I am driving and I come up to I see that, the light has turned green, and, so I want to proceed through the intersection, and then all of a sudden, someone coming from the other way, speeds through and goes through the red light, and they almost hit me. Oh my goodness, that was so close. Did you see that maniac? They almost hit me with their car. Did that person breach their duty of care? If the person ran a red light and almost hit me, did that driver breach their duty of care to me as a fellow driver?
Yes.
Yes, they did. Can I sue them?
No.
No.
Yeah, it was a near miss. Right now, I might want, if I wanted to, I may, call the police, and if they're driving unsafely, maybe report that, hey, I don't know if this person's under the influence, or I don't know, this person's being unsafe. You can give the police a heads up that someone's being super unsafe, but there's nothing I can really do in the way of taking that person to court to sue for what? To sue for the fact that they almost hit me? That's not enough. This brings us to the next thing, causation. Okay, causation is defined as a direct factual link between breach of duty and the injury sustained by the plaintiff. I'll say that again because there's a lot of kind of legal words kind of being thrown around here. A direct factual link between breach of duty and the injury sustained by the plaintiff. It's kind of like hitting the rewind button and connecting the dots. Okay, I know I'm kind of mixing metaphors here, but the idea of connecting the dots is to see how things are put together. And the idea of rewinding is to sort of trace to trace backwards. And so if we look at somebody, I'm just going to sort of kind of free flow write stuff down as I'm talking. Okay, so victim has a broken leg. All right, well, let's backtrack a little bit. How did that leg get broken? Okay, that leg got broken. Leg was broken because it was struck by the bumper of an automobile. Let's keep going back. Why was it struck by the bumper of an automobile? The automobile ran a red light and struck the victim while they were crossing the street. The automobile was being driven, if I could spell, by the plaintiff. Nope. Defendant. The plaintiff is the victim here. So if we kind of connect the dots backwards here. Okay, if I'm the victim, I have an injury and I feel like I deserve compensation. Well, I need to then be able to make the case, the direct factual case as to how I wound up in the condition that I am. I have a broken leg. Why is my leg broken? Because I was hit by the bumper of a car. The car was being driven by the defendant, and the defendant ran a red light and hit me while I was crossing the street. So what I'm trying to do here is make a direct factual link between why I'm injured and how we got there. So I've been injured by the, I've been injured by the defendant because I'm making the argument that since they were driving a vehicle, they owed me as a pedestrian a duty of care to pay attention and follow the rules of the road. By failing to observe the rules of the road, by failing to stop at that red light, they breached their duty of care. Not only did they breach their duty of care, by striking me with the car while they're breaching their duty of care, I am now injured. I'm making a direct factual link between the actions of the defendant and my injuries. That is what causation is. You have to make a direct link between the actual injuries sustained and the actions of the defendant. The same thing could be applicable if we were looking at in the textbook where they were saying, like if you didn't clear snow off of your walk, so to speak. Like let's say that you are expecting, an Amazon package, like a lot of people are these days, and then there's a terrible snowstorm and you've got ice all up and down your walkway, and you just decide, yeah, you know what, I'm a little bit too lazy to I don't really feel like going out and shoveling. Well, if you're expecting people to make deliveries to your house and you are actually not, then you actually owe visitors a duty of care. It doesn't mean that you have to be like my dad and be outside during a snowstorm shoveling. He likes to do that. Some of you might be like, hey, that sounds like my dad. I haven't quite inherited that gene yet. I am a father, but I still, don't see the need to shovel during the snowstorm. I'll wait till it's done. But yeah, if you just decide to just leave the snow as it is and it, freezes up and, the walkway to the front of your house is actually an icy death trap, you are actually opening yourself up potentially to liability, because if someone were to then slip and fall and injure themselves, they might actually have a civil suit. Now, again, whether or not they actually decide to sue you depends on the extent of the injury. Sometimes it's just embarrassment, right? You watch FailArmy videos and you see, people slipping and sliding, and usually it's just a matter of they kind of get up and they go about, their daily life. But if someone actually faces real injury, to the fact that then they can't continue to work or they need, hospitalization, then you as the homeowner could actually be found responsible, again, not criminally, but as a civil matter for breaching your duty of care. You need to know these things. Again, you've been shielded from this a lot because at the stage of your life right now, you don't have the weight of liability hanging over you because you are still minors. But I've seen the memes, right? They say that, you know, when they talk about, you know, growing up and how it's supposed to be like so much easier and so much, there are a whole bunch of additional things that you unlock when you become an adult that you have been shielded from because of your age. I'm just checking the chat right now. Oh, good to see that Edsby's now working. That's good. So, all right, here we go. Duty, breach, causation, and damages. I'm going to stop the. I'm going to pause the recording. Okay. So I'm kind of moving back and forth, you know, in this question packet, and that's fine. Kind of going back up to the beginning again. I want to look at. I'm going to skip this burden of proof thing right now. I want to really talk about the idea of the reasonable person, common sense, and the concept of foreseeability. In fact, no, I won't switch them around. But I want to talk about those things. The reasonable person, common sense, and foreseeability. We're going to go to the textbook as well. If we look at breaching a duty, there are factors that need to be considered. I mean, one of them, and I already mentioned it, and you can see if you scroll down here, minors and a duty of care. A child cannot be judged by the standards of an adult reasonable person. Okay, this doesn't mean that a child or a youth is completely and totally off the hook from any sort of liability, but it does mean that you are not held to the same standard as someone who is an adult and someone who by definition should know better. I want to look at this vocabulary term because it's kind of a strange definition. Who is the reasonable person? We're not actually talking about, this is not a trivia question where you're like, oh, I know who that person is. It's this guy. It's not an actual person. Okay. And I actually need to unpack this definition a little bit because at first glance, it can seem to be really offensive. The reasonable person is an image of someone who has neither physical nor developmental disabilities and who people agree is careful, thoughtful, and considerate of other people in all dealings. I want to stop there for just a second. Again, at first glance, that might cause you to sort of, you know, do a double take and be, wait, what now? Like when it talks about being reasonable, it means you don't have physical or developmental disabilities. And you're like, so what are you saying? If I have a physical disability that I'm not reasonable, that I can't use my mind, that I'm somehow less than human? Or no, that's not what this is saying. It's actually saying, and this is why you have to understand that this is from a legal liability standpoint, someone who suffers with a physical disability may be given additional protection under the law in regards to what they are expected to be able to do. It has nothing to do with human rights. It has nothing to do with your equality in the eyes of the law. It actually has to do with additional protections that someone who has physical or developmental disabilities, the additional protection that they may have if someone tried to sue them. And here's a perfect example for it. If you, for example, have lost the use of your legs and are in a wheelchair, whether it's actually from maybe it's temporary and you are recovering, or it is something more terminal and you've lost the use of your legs and you're in a wheelchair, that might make it more challenging for you to be able to actually like shovel a driveway. It has nothing to do with your ability to use your mind and to, you know, enter into conversation with people and think and be creative, but it means that you may have a difficult time performing certain actions that someone who doesn't have those challenges, you know, would be able to do. So really, when we're talking about the idea of the reasonable person, it's not it's not designed to be this ideal in which everybody is aiming for, and it is the pinnacle of human achievement. It has everything to do with trying to draw a line to determine when has someone acted responsibly or when have they not. This will become a little bit more clear as we work our way through it. Okay? The reasonable person is never expected to be perfect. Okay? People make mistakes. I don't want you to hear, that I'm saying that like, oh, if you don't shovel your driveway, you're going to get sued and all these other things. And actually, quite frankly, in Canada, we don't have as many kind of lawsuits as they often do in the United States for numerous amounts of reasons. I don't have all the time to get into that, but you'll find that the idea of people suing one another isn't as prevalent in Canada as it is, south of the border. When we look at what is considered reasonable, I have a question for you. I gotta stop the sharing. Oh no, I don't. I'll just ask this. I can't see you right now. Does anybody here know what a block heater is? Anybody at all without Googling it? Anybody know what a block heater is? In regards to automobiles? Is that a no? Guess what? That's okay. The reason why that's okay is because of where we live. We live in Southern Ontario. Sure, we get winters, but our winters aren't nearly as bad as other parts of the country. Let me tell you this. If I ask that question, does anybody know what a block heater is? And I ask that question in North Bay or Timmins or Edmonton or anywhere in Saskatchewan, pretty much every hand would go up and everybody would be able to tell me what a block heater is, because block heaters are actually, they're not standard issue on cars. You usually have to actually get them installed. Block heaters are actually devices that in very, very cold temperatures, you actually plug them in. It's not an electric car, but it's designed to actually keep the oil in the engine from getting too cold. It makes the car easier to start in the morning, especially on very, very cold days. So if you've ever, you've tried to, your mom or dad has tried to start the car on a really cold day and you hear that like, and it won't quite start and it won't turn over. One of the ways in which that can be remedied is, with something known as a block heater. And again, you're like, Mr. Seidenberg, why are you talking about this? Well, I'll tell you why. This just goes to show you that what is considered reasonable isn't the same in all places and for everybody. A lot of it depends on geography, cultural expectations. It's as another kind of funny example of this, most Canadians, well, I shouldn't say most, but winter tires are much more common in Canada than they are in the United States, per capita, meaning as a percentage of the population. There are lots of places in the United States where they don't get snow at all. And when there is snow, people start freaking out at even the fear that snow is coming. You see memes where, in Florida, if a single snowflake hits the ground, there's like 10 people in the ditch. And I mean, we laugh at that sort of thing sometimes because, these people don't know how to drive in the winter. Well, it's also because they're not used to those conditions because of the area in which they live. In Canada, you want to prepare for winter weather. You want to make sure that you've got your ice scraper. You want to make sure that you've got your snow brush. You want to make sure, actually, generally speaking, that you have some sort of, shovel or, that sort of stuff, or a bag of salt in the trunk of your car. And if you don't, well, maybe you should, right? It's good to have for potential traction. You never know when you might be able to help somebody. It's part of being prepared. The level of which a person is held to the standard of a reasonable person varies from place to place. Okay? And so I'm just going to read here. A person or company whose conduct falls below the expected standard of care is liable for the results of the negligence, even if the party was acting within the law. For example, Anya drives at the posted speed limit during a snowstorm and hits a pedestrian. What would be the reasonable thing to do if it is snowing, based on your young driver's training? What do they tell you to do? Do you drive according to the speed limit?
Oh, you drive a little slower.
You drive according to the conditions, right? You drive according to the conditions of the road, conditions of the weather, conditions of other traffic. So it doesn't matter if the posted limit is 80 kilometers an hour. If it is snowing and the road, it looks really, really icy and visibility is limited, the reasonable person would drive slower. Now, to be fair, you might say, well, how much slower, Mr. Seidenberg? It's not an exact number thing. It's not like, it's not an equation where you do, well, okay, if it's snowing, you cut the speed exactly in half. That's why they actually use the term reasonable. It's not actually determining an exact number. It's basically about the idea of common sense. What would be the common sense thing to do in a situation where, hey, look, it's snowing. That probably means the road is slippery. If the road is slippery, that means it might take longer for me to stop. That means I should probably slow down. None of this is rocket science. None of this is something that you actually need a degree for. Okay, the reasonable person doesn't mean that you need to go to college or university, right? You can start being the reasonable person right now. It's tied to the idea of common sense. It's how someone who doesn't suffer from physical or developmental disabilities would be expected to act in a situation. So, perfect example there. Hey, it's snowing. I should probably slow down. I now want to talk about this next term, foreseeability. I call it the common sense superpower because I want to break down the word. Define foreseeability in your own words. Foresee ability. What's an ability? Like, just define the word ability.
Like something you can do?
Something you can do. What does it mean to foresee?
To see in advance.
Kind of, yeah, to like kind of sort of almost like it's like seeing into the future, but I'm not talking about like fortune teller stuff or anything like that. The concept of foreseeability is the ability to make an inference as to the consequences of one's actions. If I do this, a likely outcome would be, insert whatever it is. That's all foreseeability is. And the reason why I call it the common sense superpower is anybody can do it. Not everybody is good at it. In fact, a lot of times a big part of parenting is trying to teach children how to do it. Because at a certain age, they are incapable of foreseeability, right? If you're 2 or 3 or 4 years old, you know, you can't foresee that, oh, if I walk into traffic, I could get hit by a car and I might die. Like, your brain's not ready for that. But just like we talked about capacity and the Youth Criminal Justice Act, as you begin to go into adolescence and into your teenage years, your ability to see how, oh, if I do this thing, this is a likely outcome, you're able to do it. Sometimes you just ignore it. Classic example. How many of you have been watching a show on Netflix and you know it's like 11 o'clock at night and you know you should probably go to sleep, But then you think to yourself, just one more episode. We've probably all done it. Okay. I've been there too, especially with foreseeability. A lot of times it's related to food. I know sometimes it's been like 10 o'clock at night, and I have a weakness for Tostitos brand queso dip. I know it's not real cheese, but I love it. And there's been times where it's just, there's a whole bag of Tostitos and there's a whole jar of the queso dip, and I'll just sit there and I'll just eat it all. And I know the whole time that I'm probably going to pay for it later, but I ignore it. It's dumb. Foreseeability would say, hey, Eric, because that's my name, you've been here before. You know, if you eat that entire bag of chips right before going to bed, you're probably going to have tummy trouble. It's going to happen. You know this. Why do you do this to yourself? Again, whether or not we listen to that little voice doesn't mean that we are incapable of doing it. Okay? So the concept of foreseeability, and I'll actually read directly from the text. The concept of foreseeability is related to the concept of the reasonable person. Asking the question, would a reasonable person in similar circumstances have foreseen or been able to predict the injury to the victim as a result of his or her actions? Determines to a large extent tort liability. If the answer is yes, fault and liability exist. If the answer is no, then there is no liability. If the defendant has not met the reasonable person's standard of care, then the defendant has breached his or her duty. In our earlier example, Liam should have foreseen, meaning that, if I don't clean my walkway, someone could slip and fall and be injured. Foreseeability is a difficult standard to apply. The courts have tended to follow the principle that the defendants should not be held responsible for any results of actions that could not reasonably be expected. For example, if Alden carries a gun that discharges as he falls, shooting a neighbor, Liam is not liable for the neighbor's injuries. And there's a lot going on there, but we will talk about a little bit later the concept of, we're not going to talk about it today, we'll talk about it tomorrow, what they call contributory negligence, which is kind of the idea of, yeah, you were injured and somebody's at fault, but you're also partially at fault for your own injuries. I think this is pretty much where I want to wrap up today. We've covered basically, we'll talk about snail in the bottle case tomorrow. That'll actually be the first thing that we talk about, and then we can get into 12.4. So I want to come back again to, if we look at the reasonable person and suing and foreseeability, I want you to know I'm 36 years old. I have never been sued for negligence. Okay? I don't want this chapter to like scare you into living your best life, or to like missing out on things because you're afraid, oh, I better not do that, I'm going to get sued. I better not do that, I'm going to get sued. That's not what this chapter is all about. What this chapter is designed to do is to say that as you get older, you are going to have additional responsibilities. You need to be aware of what those responsibilities are. But at the same time, as long as you are really making your best effort to be careful and considerate and, follow the rules and, not do flagrantly dangerous or, unsafe things, you're probably doing a lot to protect yourself from any sort of legal action, right? There's the old saying, when in doubt, don't, right? If it seems like it's a really stupid idea, and I know we often do make stupid like we do stupid things sometimes, you see the parking lot with the fresh snow and you think, oh, that'd be a lot of fun to do, donuts and, lift the handbrake and spin out and everything like that. It seems like it'd be a fun thing to do. And as the other saying goes, it's all fun and games until someone loses an eye, right? Sometimes what you think you're just doing in the name of fun, you don't actually see that those particular actions could have very, very negative consequences. So it's not saying give up on your dreams. It's not saying you can't have fun. It's not even saying that you can't be silly, right? You can still have, go tobogganing and have snowball fights with friends and stuff like that. All it's saying really is before you act, take some time to really reflect and think to that little voice. Try to build the volume of that little voice inside of you that says, how could my actions affect another person? Because if it seems like it's probably a dangerous or reckless idea, then it's something that you shouldn't do. Also, if it seems like it's a good idea for you to, clean something up, or if you see like, oh yeah, that looks dangerous. Somebody could get injured by that. I should probably clean that up. Well, then you should listen to that little voice. And just by doing those little things, being someone who shows common sense and common courtesy, that is going to go a very long way to you protecting yourself from any potential lawsuit in regards to negligent behavior. I'm going to stop the recording.